First of all, we want to thank God for the grace and the wisdom that God has given this tremendous team of lawyers. Advancement Project, Kirkland and Ellis, the Southern Coalition, the ACLU, the Department of Justice, Herb Joyner, who helped work with this, Jamie Cole, Al McCrory. I do want to take a special privilege of calling out the name of Penda Hare, who leads Advancement Project, Anita Earls, who leads Southern Coalition, and I just told him coming down here, the Samuel in our group, Adam Stein, who's been doing this work for a long time. And I want to ask all of us who are plaintiffs to give our lawyers a big round of applause. And then I want to thank all of the witnesses, and two of them are here today that stand as amongst the hundreds of witnesses. Ms. Rosanelle Eaton, who's a young age of 93 or 94. She's been here every day. And to Ms. Mary Perry, who's been here every day. She served as a branch president, the NAACP, was it 40? 41 years. 41 years. Let's give them a hand. And all of the other plaintiffs. Let me make some statements, and I'm going to then turn it over first to Donovan and then to Danita, and then Anita and Allison, and then Allison, and then we will take questions. You heard some of the lawyers today on our opposing side say things about party. But let us be clear, African Americans are African Americans first. And this case was about race. The history of race, the continuing reality of racial discrimination, and the things that we attempt to do to overcome the barriers that still exist. Disenfranchisement is constitutionally wrong. Getting the right to vote is enfranchisement. But then to take away those things that have been used or are being used to overcome barriers is constitutionally wrong. Racism also, and racial intent is not a calculus. It's not like an algebra formula. It's about putting policies in place that overcome barriers, overcome things that exist. And it's also about not removing them when they began to work. And that's what our state has done. This state has, in essence, removed those actions put in place to overcome barriers after they began to work. And remember what Justice Ginsburg said when the Section 4 formula of the Voting Rights Act was basically overturned. She said it's like removing an umbrella in a rainstorm because you're not getting wet. This case is about history. It's about past history and past discrimination that still exists and still impact our presence. But it's also about our place in history. And the question of this case is, will we make the mistake of the past and deconstruct voting practices that have a positive impact on opening up the franchises and overcoming continual burdens and barriers? One of the striking pieces we have seen in this case is there is nowhere in the record of these United States when states have voted to open up opportunities to overcome barriers, and then those things were rolled away or were taken back, except in the late 1870s and 80s. That's the only time you've seen it, when opportunities and policies were put in place to overcome barriers during the first part of the first Reconstruction. And then around 1870, 1880, those things were rolled back. Ever since then, we've never seen that. But that's what we're seeing in North Carolina, and that's why we're challenging it. We have proven in this case systemic, irrefutable racism that continues to exist. Racial barriers. And racial barriers and disenfranchisement have no constitutional place in our democracy. We've heard that we ought to just work hard. We've heard things that suggest that voter anger. But one of the things that Reverend Michelle Laws, our executive director, noted to me in the hallway was our participation in this democracy should not be dependent on a level of duress that is in our community. And over and over and over again, even the court, even the judge said the government should not be in the business of making it harder to vote. And it is proven that before House Bill 589 became 57 pages of voter suppression, early voting, same-day registration, out-of-precinct voting, registering of 16, 17-year-olds was positively overcoming barriers and burdens to vote. And the only reason for rolling it back, everything was debunked. They said fraud, that was debunked. They said consistency, that was debunked. They said it costs less, that was debunked. And once you remove all of those reasonings, what is left is an intentionality to disenfranchise African Americans. That is constitutionally wrong. It's been constitutionally wrong ever since the 14th Amendment was put into the Constitution, and it's certainly constitutionally wrong under the Voting Rights Amendment. Finally, Tom Farr, said that this is not a Section 5 case. He kept saying that. In other words, what he's saying, they know that if Section 5 was still in force, they would have never made it through pre-clearance. They would have never. But just because it's not a Section 5 case does not mean it's not a violation of the law under Section 2. He said, Tom Farr said, factors of disparities should not be considered. Personally, I almost fell out of my seat. To suggest in America, where we guarantee equal protection under the law, that disparities should not be considered, and that we should accept what's called impoverished democracy and not worry about that. In other words, that we should allow barriers and allow burdens, is quite concerning. He said there's no precedent for a case like. He's right, because there's no precedent in America where a state has ever gone forward like this, and then simply because people got electoral power, they then rolled back. The question in this case is the question that has always been: why is it that the legislators and the governor here in North Carolina do not want people to vote? And when you unpack that vote, unpack that rationale, is because they do not want African Americans to vote, because they're afraid that African Americans will not line up with their extremist agenda. They also said, he said that the state should just be able to do what they want, basically, in voting laws, no matter who it burdens, because policy in the state is up to the state. Well, we heard that years ago. That was the argument of Jim Crow. It's a state policy. That was the argument of Jim Crow. He also said, well, the voting percentages went up a little bit in 2014, so that means that the law wasn't discriminatory. Let me say something to the media. This is something my mother and father, but also when you study history, you learn this. When segregation was the law of the land, black graduation rates still increased a little bit because black people worked hard and they learned how to deal with segregated schools. But they never accepted segregated school as being legal. So just because you overcome a barrier does not mean that the barrier is constitutional. I like the way the former chair of the UNC Law School says it. He said that just because you tilt a pool table up on this end and somebody figures out how to make the shot from the other end with the end tilted up does not mean that's how you play pool. It's supposed to be a level table and a level playing field. He also said that we should be able to adjust. I thought that was a striking argument, Don, that we should just be able to adjust and figure it out. Democracy should not be a maze. It should not be made hard and then people should just have to figure it out. Democracy should not be survival of the fittest. No. Democracy should be protecting one man, one person, one woman, one vote. And we should want more people voting, not less people voting. This case has proven a sad day in North Carolina that we intend to correct. And that is, right now in North Carolina, here's the context we're in. We're in a state where a legislature and a governor are more interested in protecting Confederate monuments and protecting the battle flag of the Confederates on car license plates than they are interested in protecting the right to vote and protecting voters against voter suppression. That is why we fight. That is why this is our Selma, and that is why we believe ultimately we will be victorious. Donovan, Danita, attorneys, would you all step up? Anita, Ms. Briggs, come on.
Good afternoon. I'm Danita Judge, and I'm senior attorney with Advancement Project, and we represent the North Carolina NAACP in this lawsuit against the state of North Carolina, specifically Governor McCrory. Over the past 3 weeks, we've been here and we've put on significant evidence to show that the state of North Carolina knew and intentionally passed House Bill 589 to discriminate or make it a burden or make it extremely difficult for African Americans to vote. We believe that we presented a strong case and that the case speaks for itself. That many of the voters, witnesses that you saw, while some of them may have been able to overcome the barriers, it was a barrier nonetheless. And many of them were not able to overcome those barriers. And we know as we leave here today that we have a strong case. We believe in what we put forth before the judge. We believe strongly that this law was wrong, that it was hurtful to the African American community, and we stand in solidarity with all of the citizens of North Carolina to prevent laws like this from being passed and making it more difficult for people to vote. Our voting is our fundamental right in this country, and none of us should have to overcome hurdles and burdens to be able to cast our ballot for those we believe that will represent us in a way that we feel strongly need to be represented. And so as we leave here today, we leave our hearts in North Carolina with the belief that we shall overcome. We shall overcome. Thank you.
Anita Earls with the Southern Coalition for Social Justice. I want to thank Reverend Barber for his lasting, long-term, and inspiring leadership on voting rights. For the past 3 weeks, we've had our day in court on this case. I want to let you know that our struggle with the NAACP for voting rights continues August 31st.
That's right.
When we argue in the North Carolina Supreme Court that the redistricting plans that were enacted for the legislature and Congress were racially gerrymandered, and following the Supreme Court's decision in the Alabama case, the North Carolina Supreme Court needs to overturn those plans. But today really goes to Allison Riggs, the lead attorney for Southern Coalition.
On the 50th anniversary of the Voting Rights Act, it's a sad day that we still need its vigorous protections. And that's what we've been doing for the past 3 weeks, is demonstrating that. As sad as it is to be having to fight this fight still today, it was an honor to represent our clients, the League of Women Voters, A. Philip Randolph Institute, Common Cause North Carolina, Unifor, and all of our individual clients, and to work in coalition, close coalition, with the NAACP, the Department of Justice, the team that got together behind this case was stellar. And what I hope folks walking away today realize is that this trial was about the voice of North Carolinians, people who were disenfranchised this last November, who will be disenfranchised going forward. They came out, they said this isn't okay, we're fighting back, and that's what we anticipate the courts will recognize. Thank you.
As you all know, we've just finished 3 weeks of trial in this case. Julie Ebenstein from ACLU. And in 3 weeks, we have not received a single justification from the state for why they passed these laws that disenfranchise hundreds of thousands of voters. Their attorney stood in court today and said they don't need to provide a justification for rolling back the fundamental right to vote. And all the attorneys here today and the brave clients, our brave clients who stepped up to protect their rights and the rights of other North Carolinians, want an explanation for this law. They want these laws to be rolled back, and they want this voter suppression to stop immediately. It was our privilege to represent people who are willing to step forward and protect all North Carolinians' rights to vote. Thank you.
Now we want to bring on, thank you so much, Donovan, who closed us out and opened us up. Let's give her a hand. Brought us together, held us together.
So it's been my privilege to really work with a coalition of great attorneys and Reverend Barber and witnesses. I think the key takeaway from this, as you look at this trial, this is a history lesson. This isn't the first time this has happened in North Carolina. In the late 1800s, the same thing happened. African Americans were voting, their registration and turnout increased, and what happened were laws were passed to stop that. Nothing stopped those laws from going into effect, and African American voting rates dropped, and they dropped almost to zero. And not until after the voting rights of 1965 did they start to increase, and slowly. And here we are again today, and Ms. Eaton is with us, and she was there then, and she's there with us today to show that even today, as African Americans and others here in North Carolina, that many often refer to as just collateral damage, really are people who are disenfranchised. And what this case shows is that it has to be stopped. And this case is about the Voting Rights Act and the Constitution, stopping that. Stopping it before that great harm we've learned from history will happen. And that's what we intend, that's what we fought for, and that's what we expect this court to enjoin. Thank you.
Mr. Donovan, could you stay there and take some questions, please?
Sure.
Is there any comment or question that the judge made today that stands out in your mind?
Well, I think one was, the judge rightly waits to the end of evidence to really comment on it. I thought his comment that it was, at least in his mind, perplexing why the state of North Carolina made it harder for everyone to vote, and the defendants really had no response. So to me, that was at least a comment on the evidence.
Was it discouraging to hear the judge ask for proof of tracking in terms of a negative effect on voters?
No, that's what we proved. And actually what you have to prove under Section 2 is, first of all, that there's a disproportionate impact. And even the judge said at the beginning, you don't need to go through that. I recognize that. And then what the Fourth Circuit has said, what you look at is what are the socioeconomic factors. That's what Reverend Barber said. The state's counsel tried to say you shouldn't look at. And even the judge said, the Fourth Circuit said, I have to look at that. So that's the harm. You look at the burden. You don't wait until the burdens show themselves so greatly that people are great numbers rather than what we have now are numbers, but they're getting worse in every election.
And we've made that mistake before in history. That's why I said this is about. In the 1800s, when they began to roll back, when extremists took over the legislature after Reconstruction, they deconstructed laws. Now, the numbers actually didn't plummet immediately. In fact, in 1896, you had one of the highest turnouts ever, but then it kicked in and it just plummeted. The other thing we know is that what the defense is trying to get the courts to say is you can't touch us. In other words, we're going to test this and see if you'll touch us. If you don't touch us, they could go back and remove everything. I mean, they literally are saying this is state policy. We could do this. So this is a critical moment. This is a pivotal case for America. We win. It says to these legislators around the country, particularly out in the South, just because we don't have pre-clearance right now, that you know you couldn't make it through, doesn't mean you have carte blanche to just roll back provisions that have been put into law in statute in order to overcome barriers and burden. If the court rules the other way, it says it's open season. It's open season. And I think the thing that struck me the most was the judge said at least three times, the government should not be in the business of making it harder to vote. Why did you do this? Why did you do this? And they did not offer any justification, and the justification they did offer did not uphold. See, they were able to say one thing in political campaigns. This is not a political campaign, this is a court. Out in the politics, you don't get cross-examined. Under cross-examination, their claim of fraud was proven fraudulent. Under cross-examination, their claim of things being more expensive was proven not to be true. You see, every so-called justification they had was basically torn apart and rendered and neutralized. In fact, not just neutralized, proven to be actually a false claim. Red meat that they were serving to the public, but it could not stand under the microscope of the Constitution and the courts. Thank you all so much. We'll see you when it comes time for the decision. All right. Y'all, let's have a quick one. I know.